Welcome to Chapter 2 of the American Court System in our textbook, Judicial Process. Chapter 2 will be addressing law and legal systems. In this chapter, we'll discuss what is law, and you'll be doing some reading in your Law in the Bible book, which will also address that question. We'll address in this chapter how legal systems are organized, the components of U.S. law, and interpreting the law. Law pervades our lives. Law is a body of rules enacted by public officials in a legitimate manner and backed by the force of the state. You'll be reading as well in your Law in the Bible book about natural law or the moral law or the law of God. That not only is there the civil law that is enacted by public officials in a legitimate manner and backed by the force of the state, there's also the law of God that is promulgated by God, that is in accord with God's nature, and that is also enforced by God himself through natural means and even supernatural means. For our purposes here, civil law regulates the public and private institutions that are a central part of our lives. Law is a word of many meanings, and it's quite difficult to define, even though you may think it's relatively straightforward. The reality is that the definitions of law do not necessarily include justice. Justice is fairness in treatment by the law. The term justice is used in many ways. Justice is winning. Justice is achieving desired results, good versus bad results. Justice is equated with normative values of right to privacy versus rights of the unborn. Law and justice sometimes mean the same thing, but not always. And so we work in our civil system to make sure that the civil law is just, that is, that it is fair in its treatment of each other. This slide presents some information from Table 2.1 in your textbook, Major Legal Systems of the World. You can see there are the four major legal systems: common law, civil law, socialist law, and Islamic law. First, let's discuss the civil law. Civil law, also called Roman law or Romano-Germanic law or continental law, is the oldest family of law in the world. It starts with a code, a compilation of laws, and the code is expressed in rules of law as general principles, and the code provides answers for all disputes. Civil law or the Roman law, is the oldest form of civil law in the world, but it's certainly not the oldest form of law in the world, as we live in a world that is governed by God's law. In civil law, judges, not lawyers, dominate the court hearings. For example, judges call witnesses, where in our legal system, lawyers call witnesses. Maybe the most prominent form of civil law is the French legal system, which is also currently enacted in the state of Louisiana. Under this system, judges tend to be career bureaucrats who have not been practicing lawyers. And juries are not generally used. Instead, mixed tribunals of judges and lay citizens are used in serious criminal cases. Next, we have the socialist legal system. The socialist system originated in the former Soviet Union, what is currently the nation of Russia. This system is partly based on the civil system or a code system, but it is also revolutionary. Law is to be used to create a radically different society in the socialist system. The socialist legal system is based on the philosophy of Karl Marx and Vladimir Lenin. The societal ownership of and core to its philosophy is the societal ownership of the major means of production, which is a guiding principle. The socialist system rejects law as a fundamental basis for society. Instead, law is the arbitrary work of an autocratic sovereign. The primary goal of the socialist legal system is the protection of the state. Private property receives less protection. Law in this system has an educational role. It's an instrument of educating members about the new socialist society. Islamic law is a form of religious law. Most legal systems of the world are secular or have no reference to an explicit deity, but not all legal systems. Islamic law is one of those legal systems, and it's termed the Sharia law. The Islamic legal system is based on the Quran, which sets out principles revealed by Allah or God, and the Sunnah, which contains the practices and decisions of Muhammad, the Islamic prophet. Islam and Islamic clerics influence the law in those areas, in those countries that use Islamic law. The fourth legal system is the common law, which is the legal system, the legal tradition that the American system is rooted in. Common law traces its roots to medieval England. After the Norman conquest of 1066, the king's courts began to apply the common customs of the entire realm rather than just one village. Common law came to be viewed as general law as opposed to special law. That is, it was the law common to the entire land. Table 2.2 gives you a historical timeline of key developments in the law, starting with Hammurabi's first written code of law, approximately 1800 years before Christ, all the way to the fall of the Berlin Wall when the Soviet Union was dissolved and a socialist legal system was dissolved in 1991. Let's think a moment about equity at common law. We'll spend a few moments here discussing the common law, and in particular the principle of equity. The common law became technical and evolved into a hard and limited law. Common law remedies were largely limited to monetary damages. The refusal of judges to adapt gave rise to equity law. Equity meant fair dealing and equitable remedies were more flexible. That is, instead of strict monetary damages, there could be remedies in equity, remedies in fair dealing, and flexible judgments like injunctions. The common law has an English heritage with major American adaptations. Colonists in the Americas brought principles of British common law to the America. They brought procedures but did not always apply the substance, and law was adapted to the frontier society. And so by the 19th century, most states had merged their separate courts of law and equity into one major court. Today, the term common law simply refers to the case method system. That is, when a court of competent jurisdiction issues a case or opinion, that becomes part of the common law that is referred to by the lawyers as they prosecute and adjudicate cases in the legal system. Key characteristics of the common law is that the law is judge-made law. That is, that each individual case that is set down by a judge becomes law or has certain legal principles embedded in the opinion. That means that when these opinions are issued, these judge-made laws have precedent. That is, that when there are similar facts and circumstances surrounding key disputes, then other like cases have precedential value in those cases. This is an uncodified rules and regulations type of system, meaning that there are cases that must be researched and legal principles that must be argued in order to ascertain the applicable rules and regulations or laws in any particular case. What is judge-made law? Well, until the late 19th century, there was no important body of statutory law in the United States. That is, that in the early United States, there weren't statutes. There were simply judge-made rulings. So common law courts developed rights in the area of property and torts, wills, and contracts. And the courts, defined such felonies as murder, manslaughter, arson, robbery, larceny, and rape. Common law's most distinctive feature is the development of a system of law based on judicial decisions. These judicial decisions that serve as the basis of the common law have authority for deciding similar questions of law in later cases. This is also referred to as the doctrine of stare decisis, which is Latin for let the decision stand. Sometimes statements in a case are not interpreted as precedent, but rather opter dicta, or dictum, or dicta, the part of the reasoning in a judicial opinion that is unnecessary to resolve the case, but yet it is helpful to a case or helpful to the reasoning, but it is not considered precedent. Reliance on precedent is central to the common law approach. Relying on stare decisis or precedent provides stability and coherence and predictability to the legal system. Justice Louis Brandeis, a Supreme Court justice of the 20th century, said that stare decisis is usually wise policy because in most matters it is more important that the applicable rule of law be settled than that it be settled right. In addition, common law is made up of uncodified rules and regulations. That is, that there is no one place to look for a statement of quote unquote the law. Instead, the law emerges through precedent found in court decisions. So common law judges and lawyers reason by analogy, which allows leeway in formulating new legal rules or modifying old ones, because analogies are neither correct nor incorrect, only more or less persuasive. Judges in this system may distinguish a current case from previous ones by pointing to different circumstantial factors or other variables that may distinguish one case from another. Judges may find that a case differs from all previous cases, or that a previous case was wrongly decided. The common law is also an adversarial system. It's an adversarial system of civil law, or adversarial system in our civil law and criminal law system. But under the civil or Roman law system, it was inquisitorial. The difference is that common law has lawyers that advocate or are adversaries in the system for one party over another, whereas the civil or Roman law has judges who ask questions to try to ascertain the real issue of the matter. The parties are responsible for calling witnesses in our common law system and asking the questions. In our system, a judge acts as a neutral decision maker, presiding over a battle between opposing parties. This has raised the question, the adversarial nature of our system has raised the question of whether our system is the best system for finding the truth. Each party has, it is the responsibility of the parties, not the judge or the jury, to define the legal issues and facts in a case. This system encourages each party to present its best case and make its best arguments. The judge is a neutral arbitrator and expected to be passive in the case, ruling on certain procedural matters or addressing or helping the jury in understanding the issues at hand. And the judge must be free from pressure, an independent third party in the whole system. Table 2.3 introduces us to major components of U.S. law: federalism, civil law and criminal law, the sources of law, substantive versus procedural law, judicial decisions, remedies, public law and private law, and doctrines of access. The doctrine of federalism divides power between the national and state governments. Federal law refers to the law of the national government, or in our case, the federal government in Washington, D.C., and it applies across the nation. State law applies to its citizens within its territory. For instance, Texas has its own legal system that applies to Texas. It's extensive and it's diverse. For example, it ranges from business to marriage laws. Even within the state, there are local laws that apply to limited geographic or functional areas. States grant local jurisdictions legal powers, and so in that sense, the states also agree to abide by federal law. So in that sense, the state is really the center of the American system, with the federal government being a creation of the states and the localities being creations of the state. In our system, there are multiple sources of law: federal, state, and local. There are constitutions, the top rung of all law, whether in the federal, state, or local system. These constitutions specify how government officials will be selected, and federal and state constitutions will and do vary. Another source of law is the statute. Statutes are laws that are enacted by a legislative body at the federal, state, or local level. Today, legislation is enacted law, and it's extensive and very common, whereas in the 19th century it was not. Another source of law is administrative regulation. Rules and regulations adopted by administrative agencies at the federal, state, and local level have the force of law. So, for example, IRS regulations and decisions are law. Nursing home standards promulgated by different regulatory bodies, that's law. Local zoning regulations, that's law. Administrative regulations are the newest and fastest growing source of law, and we will deal at some point in this class with the Chevron doctrine, which is a famous case dealing with administrative regulations. Let's think now about judicial decisions. Judicial decisions are appellate court decisions that are very important as a source of law. Legislatures pass law wholesale that make courts, legislatures pass law wholesale, courts make it retail. That's a quote from Milton Friedman in 1984. U.S. law today is primarily statutory and administrative, but some areas, for example, tort law and court procedures, are dominated by judge-made law. Case law is important in determining the meaning of other sources of law. Table 2.4 tells you how to read a legal citation from a Supreme Court case. I encourage you to review it. Let's think for a moment about public and private law. Public law directly involves government, for example, constitutional, criminal, administrative, and international law. Private law governs the relationships between private citizens. So tort law involves the legal wrong done by one party to another. Not really private, it relies heavily on the actions of public agencies. For example, divorce law governs private relationships, but involves court decisions. So private law is something of a misnomer because it still involves public agencies, but there is a difference between the public law and the private law. What's the difference between civil and criminal law? Well, a civil suit involves a dispute between private parties. Criminal suit involves a violation of a government's penal laws. There's a difference between who has been harmed, individual versus state. So when an individual has been harmed, then that would include a civil dispute. But when the state has authority to enforce the law, then it's a criminal suit. It also differs in the types of remedies. Under civil law, you might have compensation versus remedies of equity. But in a criminal law, you have prison sentences and fines or probation. There are different types of criminal violations. A felony is a more serious criminal offense that involves a possible prison sentence of 1 year or more. A misdemeanor is a less serious crime that usually involves a possible prison sentence of less than 1 year. Criminal and civil law can sometimes overlap. So, for example, a drunk driver who kills someone could be prosecuted as a criminal, can also be sued under civil law for the harm that was done to that individual or his estate or family. Now, what's the difference between substantive and procedural law? Well, substantive law defines legal rights. The law defines the legal relationship between the citizen and the state and among citizens themselves, whereas procedural law establishes the method of enforcing those rights. It governs the conduct of cases in court, protects against arbitrary government actions, and is the central idea to procedural law is the idea of due process. What are remedies? Well, remedies occur when there's a judgment. A judgment is entered as a court's official decision about the rights and claims of each side in a lawsuit. The remedy is the relief granted by the court. And remedies include declaratory judgments or a judicial determination of the legal rights of the party, as well as restitution, the return of goods a party is entitled to. The most common remedy, however, is monetary damages. There's compensatory damages, payments for the actual harm that is suffered, such as medical bills or lost income. And there's punitive damages, monies awarded to a person who has been harmed in a particularly malicious or willful way. Under equity law, litigants seek an injunction, a court order that requires a person to take action or refrain from action. What's the doctrine of access? Well, the doctrine of access is used to control the flow of cases into the judiciary. The court must have jurisdiction, that is, that they must have the power of a court to hear a case in question. The controversy must be a real dispute, not some hypothetical controversy. And a plaintiff must have standing to sue. Doctrines of access are judicially created and can be changed or waived for a particular case, especially in public policy lawsuits. Let's think for a moment about interpreting the law. Citizens typically misunderstand the way and how judges and lawyers interpret and apply the law. The law is not a series of precisely written and readily located rules that cover every situation. Lawyers and judges must make sense out of the words found in constitutions and statutes, administrative regulations, and previous court decisions. Some areas of law are relatively settled, while others are not, creating discretionary choices. These discretionary choices lead to interpretation. Judges and lawyers must make choices and how they understand the meaning of words, when there's conflicting laws, when there's gaps in the law. Lawyers and judges must interpret the law and apply the law in the most equitable and right manner. So in conclusion, the U.S. law is complex, it's fragmented, it's voluminous. Our common law traditions are unique and differ considerably from civil law traditions. Our legal system is adversarial rather than inquisitorial. Juries play a more important role in our system than most other legal systems. And the Supreme Court decides some of the most pressing social and political issues of the day.